Bismillahirrahmanirrahim. Good afternoon to viewers. I welcome you all to the sixth digital dialogue organized by the Lawyers Jurists Foundation and the Business Standard. Our esteemed panel today, I'll start with Mr. Justice M. Khurshid Sarkar, Honorable Judge of the High Court Division and Supreme Court of Bangladesh. And our second guest, Mr. Ajmalul Hossain QC, Senior Advocate, Supreme Court of Bangladesh. And our final guest, Mr. Tarique Afzal, President and Managing Director of AB Bank Limited. I welcome you all to the sixth digital dialogue today. And our session in charge today, Khondukar Asma Hamid, Advocate, Supreme Court of Bangladesh. Our today's topic is advocacy in virtual courts, how effective for the litigants, what it's actually mean, how the litigants are convenient or the process becomes faster to them, or the cheaper or the understandable to them. That is actually how the litigants getting benefit out of it. Across the world, it becomes challenging for the litigants to access courts, to access justice. And if we just have a data of OECD, that's given only 46% of the world, those who are having access to courts and those who are live under the protection of law. Apart from that, even 30%, those who even don't consider to take the actions according to Hague Research Institutes. And if we just get into with the state to state, if I take example, Brazil, 80 million cases backlog, whereas in India, 30 million cases. And in Bangladesh, it's around 4 million cases. And if I divide into, like in our appellate division, 21,410 cases. And in High Court, 4,88,562 cases. And in lower courts, 30,88,291 cases pending. Even for the commercial cases, the situation is very worse. Like if I give you the example of Negotiable Instruments Acts or the check dishonor cases, even 6.17 lakh cases pending across the country, data given by the Supreme Courts. So the situation for the litigants of the commercial cases are very worse. In that situations, still there are some institutions, those are resolving disputes or the cases online resolution by it. And if we just take example, eBay, there are 60 million cases every year, or the disputes that resolve through negotiation or the adjudications, a form of online dispute resolutions. As you know, the international arbitrations going far away. There is a New York Convention 1958 following Ancestral Arbitration Rules 2010. The one, all these states, it's a mandatory for them to follow, or any institution so it makes their own resolutions or the rules, they must have to follow. There is Article 28, it specifically said that hearings should be conducted on camera, do not require the physical presence unless the parties agree or the parties desire. So it's basically the in institutional arbitration, or you say arbitration failed, the virtual court is far away. But it's not ended there. I think subcontinent went far beyond. Before than that, there is one of our very renowned Chief Justice from India, R.C. Lahoti, around 15 years before, in one of his conference speech, by supporting the litigations, for the litigants, make it easier, simpler, and quicker. He made his own words by saying it, that records of the court had to be computerized, facilitized for e-filing, and hearing through video conferencing need to be introduced. This will eliminate facts, efficiency in working of the courts, as are the outcome human weaknesses. System will be fast, neat, clean, and accessible with more ease. It would add to the efficiency of the judges. The Supreme Court has to be interlinked with the high courts, and the high courts with the subordinate courts, including those situated in the remoteness of corner of the states. And that's promoted by Chief Justice of India in 2004. So for the litigants, to make it simpler, easier, less expensive, the promotion actually going on for a long time. But if you see, Bangladesh not far away, in 2020, we have a statute. It's a Adalat Kortik Totthyo Projukti Byabohar Ain 2020. Section 3, we said we do not require physical appearance for the hearing. So it's not that bad that we are online or on right path at the moment. But there are different philosophers, different writers. They developed the jurisprudence on it. And one of the great philosopher, or the writer, you can say, Mr. Professor Richard Susskind, in his own book, what he promoted, Online Courts and the Future of Justice. The way he wanted to promote the litigants, that how system can be easier for the litigants to understand their rights and obligations, to promote their options, and to know that whether if they want to appear without lawyer, still they can do, the system will allow it. And very importantly, that the online courts instead of physical courts, that's the motto behind all these inspirations. But we are not that far, I think. The era, fourth industrial revolutions, when we are talking about whether a computer can replace a judge or a computer system can deliver decision with reasoning, or judges without courtrooms, or the justice without lawyers. This is the revolutionary changes on this era. This is what's going on in this field. And with the end remarks, I'll conclude with a very good news for the litigants, that they can have the access of justice through the digital device. According to data of BTRC, 100 million connection has taken place internet, whereas our total population 170 million. So it's a good news. Hope the litigants will have the access to justice or the access to courts through the digital device. And I will hand over to Ms. Asma. Asma, to you.
Thanks to Mr. Masoom, sir, for your excellent introduction of our panelist speakers and introducing me as the host of today's webinar. Assalamu alaikum, respected panelists and viewers. Initially, would like to welcome all of our esteemed panel members. Thank you so much for joining us today in this legal webinar series. Without any further delay, would like to begin this webinar with a question from our first panelist speaker, Mr. Tarique Afzal, sir.
Thank you. Thank you. I'm not quite confident how do I fit into such luminaries and such a learned panel. But it's a privilege and an honor to be, I got the opportunity to speak and develop or portray some information in front of the learned panel. Honorable Justice Mohammad Khurshid Sarkar, Supreme Court of Bangladesh, learned Barrister Ajmalul Hossain, Queen's Counsel, and other learned speakers. Good afternoon, and viewers as well. Assalamu alaikum. To begin with, I confirm that my discussions shall not include any sub judice matter and are purely based on contemporary information. And my limited knowledge and the limited experience that I would like to share during these difficult times, I have segregated it in a general comment, observation, and some humble suggestions to the honorable and the learned comments. I was hearing this Barrister Masum very elaborate in his opening statements and remarks. He has almost covered the contemporary affairs globally and locally, which is very enterprising. But we have some views that we would like to highlight and get some comments from the learned panel on the matter, so to ease the future for banking and for the industry at large. In cases, we have read at times and experienced that formal justice system in Bangladesh can be lengthy and at times inaccessible to those who need the most for multiple reasons. At an outset, the lengthy trial periods and implementation of court decisions becomes challenging. And in most cases, banks get included in litigations, as we all know, due to violations of contracts with clients for non-payment of loans, fraud, and related complaints, and vice versa. As you all know, recently the closure of courts due to the pandemic were also challenging for banks because cases against default clients remain pending. And that is one of our core strength and core revenue vertical. However, the virtual court system in Bangladesh under the use of information and communication technology by Courts Ordinance 2020 has resumed the adjudication processes. But still, we anticipate this may delay the disposal of cases and may further cause a backlog. So that is a general overall comment, and we have some observations that we understand. It's from a layman perspective that virtual court allows new cases to be filed. However, at times pending cases may remain unresolved. We can give example on money loan suits and some NIX, as well as Barrister Masum had highlighted in his statement earlier. Also, we heard that cases are stuck and awaiting court transfer for ownership certificates for mortgage property, which is a major risk mitigating factor for a bank, because that's one of our high prioritized collateral. Also, obtaining a certified copy of judgment from the court is at times unavailable. Hence, completion of the title transfer process remains incomplete. At times in cases, and I have a first-hand experience on this, our counsels and representatives were unable to pursue a police warrant execution as warrant copy never reached the police station on time. And we had been very vocal in the press and in public on potential defaulters, that we prosecuted them on Negotiable Instruments Act, and the copy of the warrant never reached the police station on time, and hence we faced multiple challenges. Also, in the scenario of the virtual court, as Mr. Masum had given us a good news that 100 million people now can access. But however, having said that, technological challenges can lead to an interrupted hearing and the reach to the general people who are actually justice seekers. And even though both the divisions of the Honorable Supreme Court of Bangladesh has new practice directives, but in reality, the courts perhaps were possibly hearing bail petitions. We have participated in sessions as well for our own interest, but I'm sure that has improved now. So the limited scale operation of the virtual courts may become a bottleneck for trying to enforce basic right to the administration of the law and justice overall. And also that can affect banks, leading to a monetary consequences. Now, this is a chapter that I'm highlighting to the fact representing the industry, but I'm sure people, the situations and the issues can be unique. It can be in a differential method. Now, we understand that access to justice is a fundamental for ensuring rule of law. And therefore, the initiative of virtual courts with limited resources and digital infrastructure is, of course, praiseworthy. And the initiatives that the Judiciary Department has taken to expedite the processes of concluding pending cases are remarkable. And I'm sure once upon a time, perhaps in 1982 or 83, if I remember clearly, there was a case conducted in an appellate court of Bangladesh stating that the court would agree video footage as evidences, and here we are today doing video conferencing on webinar. So I'm sure we have progressed in multiple avenues that has brought us to this crossroads as new normal. Now we understand that we will have to perhaps accept to this new normal scenario till such time that we see physical judges and physical practitioners appearing and arguing the way forward to get justice. Also, amendments to relevant laws has become critical to allow video conferencing to help record witness statements for both regular and virtual courts. That's perhaps a consideration the learned panel may wish to review. Also, the virtual court is already in practice in neighboring countries, as Mr. Masoom has rightfully said, and that have been proving record of accelerating in litigation processes. So I'm sure that would really assist the backlog to conclude at as soon as possible time. Finally, we believe a legal framework for virtual courts may need provisions for electronic documentation, incorporation of e-payment fees, virtual affidavits with digital signatures, and issuing certified digital copies of the judgments and judicial orders. So I'm sure once perhaps we are in the process of doing such, but once this takes pace, I'm sure for litigants and for practitioners and for the honorable judges, things would fall in much smoother and much easier and much desirable and understandable in the profession and in the practices of the judiciary to cater to the people of the country at large. Thank you so much again for inviting me. I hope I was able to highlight some facts that are in practice and the scenario at this time. Thank you.
Sir, in this aspect, we would like to know a question from you, how you are going to explain about it. That is, the virtual court system has emerged worldwide, but it has technically increased the questions of data protection, whether the process can keep information and documents in confidentiality or not. In that aspect, we want to know, are the banks satisfied with this process, or are there any requirements as a bank, as an institution prefers the virtual courts to give relief to the litigant public?
However, you are not audible in the last part of the question, but I understood. I understood the question. Thank you, Advocate Asma Hamid. Now, see, all these scenarios that are approaching now and in the post-COVID situation are basically, everything is based on assumptions. And everything is new to us and new to the system. However, data integrity and the protection of data is a primary concern, I'm sure not to the banks only, but to every system or every facilitator, including the judiciary, including the courts. Now, that will have to be addressed perhaps at a very serious level, at a different level, where there would be integrity managed and maintained in the data, because we are dealing with a mass situation here, with a mass scenario of cases pending and upcoming cases and litigation processes in the courts. So confidentiality of clients, confidentiality of the banking information and data would require to be at a high priority. I am not quite confident how prepared we are to address that issue at this time, but I'm sure there has to have some kind of mechanism to ensure that the data, the storage of data, the protection of the data would have to be accountable. Somebody will have to be accountable, and responsibility will have to be delegated under the system. And I'm sure the Honorable Court and courts will also give some guidance and enlighten their either beneficiaries or the petitioners or whoever, to ensure that the integrity of the data and the custody of the data are kept in confidence and in safety. So as I said, basically, we are all new into this scenario. We are learning every day. I'm sure there will be casualties and consequences, but I'm sure we'll learn and do accordingly over time.
Thank you so much, sir. In the same footing, again, I would like to know from you that with an abrupt concept of introducing virtual court system itself is a challenging issue. So we all wants to know that as a litigant party, are banks facing with challenges? And if so, what are they and how they are overcoming with those challenges?
Thank you, Advocate Hamid. I have responded that on the observations and general comment. In the part of the virtual courts, at times it can go backlog. As you are aware that we have multiple pending cases in money loan and in NI Act and on various forms, starting from the lower court to the apex courts. And as is, I'm not sure if I should be making this comment, as is the conclusion of the certain verdicts and conclusion of multiple verdicts has been pending. And this has been a challenge over the years in the country. And many development steps has been taken by the judiciary and the government at large. And I'm sure all legal counsel are fully aware of the fact that, we are a very highly populated country with a lot of issues. And there would always be issues in the society. So that's an ongoing process. Now, in the consequences of the pandemic and post-pandemic, as this is a very unique situation, I think we all are trying to get back to the normal scenario or catch up with all the pendings in whichever best possible we can. So yes, we do have the challenges, and I'm sure the industry at large are facing difficulties in mitigating factors from the judiciary, but we can only do so much because we are dependent on the courts and the honorable judges and the system at large to mitigate and to conclude the pending hearings that perhaps has been pending for a while. In every scenario, as you know, that we look up to the court all the time. Once our contracts are at stake, when our contracts are breached and violated by a potential defaulter, or in similar methods, in fraud or whatever. So whenever those occurs, we give that a priority for us to ensure that we are getting the favorable verdicts from the courts to ensure that the money for the bank is returned from the defaulters, because as you know, we deal with public money, and we are accountable to the people of the country. We are public servants also, because we are the custodian of public funds. So we have a moral obligation. It's a regulation and obligation that every banker has to follow. So whenever there is a breach from consequences, we would like that to be resolved at soonest. So definitely, when there is a new scenario happening through virtual ends where hearings and proceedings are limited, definitely there is a question and concern from our end because our dependencies are immense. So as you know that, yes, we do have faced challenges and difficulties, but I'm sure consequences, the situations will improve, and the courts will go back to a normal scenario. But I'm sure a parallel practice between virtual and regular courts can be the future, because today we have the pandemic, tomorrow there could be something else, and there could be cost efficiencies, mitigating pending cases on a very fast track. Everything can contribute to a virtual scenario as well. So I think that is we will have to take it as it goes. But humbly, I would like to request the honorable judge and the honorable counsels to take into consideration our humble suggestion. Thank you so much.
Thank you so much for your informative statement, sir. Sir, now I will move on to Mr. Ajmalul Hossain QC, sir. Sir, pursuing and holding on to Tarique Afzal sir's views about the concern of cybersecurity threats, I would like to know what initiatives or measures can be taken to avoid this cybersecurity threats relating to practice in virtual courts, as it falls under category of critical information infrastructure containing sensitive and confidential documents and information.
Thank you very much, Advocate Hamid. I'm grateful to the lawyers and jurists for inviting me this afternoon rather. It is evening where I am, or at least getting to be evening where I am. I'm not in Bangladesh at the moment. But thank you very much for inviting me to join as a discussant in this program dealing with virtual courts and advocacy in virtual courts. The question that you have asked is a very pertinent question about cybersecurity. Obviously, cybersecurity is insecurity is inherent or insecurity is inherent in every system that is used, and using the internet is also at risk. So obviously, as Mr. Afzal has said, there is a risk, and these risks will have to be managed. But there are, the real issue here, I think, is the issue of confidentiality, because a lot of information which pass through the wires, the net, basically is confidential, and confidentiality has to be maintained. So that is something that is a big issue that needs to be addressed. In one of the programs that I was involved in recently, I said that I'm troubled by the fact that courts are using Gmail addresses and not specific addresses for the court itself. The Supreme Court of Bangladesh, in my view, has its own website and should have its own associated email addresses as well. And so if one wants to access the filing section, then we should be able to go to filing. If we wanted to access a particular court or a judge's clerk, we should be able to have this information available. And therefore, if the website is used, then I think the risks probably associated with cyber insecurity will be managed to a certain extent. But using a Gmail address obviously heightens the risks. But as far as, if I may turn to a couple of general points, we have heard the word new normal. Tarique Afzal mentioned it at least 3 times. And so we are actually looking at the new normal and what is going to happen with virtual courts, because they are a reality today. And I have appeared in front of Justice Khurshid on several occasions, in several cases, virtually. And the system has worked very well from our experience. I'm sure you'll be able to hear from Justice Khurshid in a moment. But the fact is that although we call them virtual courts, strictly speaking, they are real courts. They are real courts of law, because we have a real judge who is appointed by the Republic to dispense justice on behalf of the Republic. And we have lawyers who are enrolled at the bar and who have rights of audience in the courts to make submissions. So the process, although the hearing takes place virtually, like this webinar is taking place virtually, but the actual business of the court is a real business, because at the end of the day, we do end up with a judgment, which is a real judgment, which affects the lives of one or other of the both litigants, I would have thought, in one way or another. So that is important. We're dealing with real courts, not really virtual courts. Hearings are taking place virtually. But the new normal, I think, is going to stay. I think as Tarique Afzal has said, that we expect this to continue. I personally think it will avoid a lot of wastage of court time, because we know that as a matter of fact, as practicing lawyers in Bangladesh, we know that the courts have to deal with processes which are fairly archaic and ancient, and although has stood the test of time, we know that it is very time consuming, like delivering judgment in open court. It takes sometimes 3-4 days. It's a pure waste of time, and the new normal should avoid it. What we should be able to have, and there are many countries in the other jurisdiction where I practice, it's the new normal has been there for some time. Judges just hand down a judgment. The judgment is sent to the lawyers the night before it is due to be delivered. So we receive it by email, and if we have any comments, then we make them. If the judge has got anything wrong, we suggest that there's something factually wrong, or something that we haven't said has been put down as has been attributed to us, then we can make some submissions on that by email, and then the judge corrects it, and in the morning he just says, this is the document which is handed down. No time is taken, less than a minute is taken in handing down the judgment. And then from that moment onwards, the judgment becomes effective. So this is something I think we would be able to achieve. I was looking at the speech that was given by Lord Burnett, who is the Lord Chief Justice of England. He gave a speech in Mansion House in the city of London about a month ago. And one of the things that he has said is that and I'm quoting from him, and he was actually quoting another judge, which is this: the idea that lawyers will be required to travel for an hour or two, wait around, and then deploy arguments for half an hour before traveling back has now gone. And I think this is wonderful, because I know that there are many occasions when I came all the way from England to Dhaka to argue a case, and I found that my opponent came along and asked for an adjournment, and the adjournment was given, irrespective of the fact that I'd taken the trouble of flying over 12 hours, 15 hours, to Dhaka, and coming to do this case. So these are the sort of things that will now be possible. We will be able to make representation before the courts from abroad, and also we don't have to come to the court building, because we know that Dhaka, the traffic in Dhaka is quite wild at times, and getting from one place to another is a problem. So if we are able to make submissions virtually, then what the Lord Chief Justice of England has said, that you travel for 2 hours, then just wait around and make arguments for half an hour, and then again make your way back. You will not be wasting time that much. So that is going to be, I think, part of the new normal. Now, whether there's going to be, you have just virtual hearings in one court, like we are having at the moment, or just real hearings, physical hearings in a court in the building, whether that is going to happen, or whether there's going to be a hybrid situation where you have actually maybe a judge sitting in this court, and some lawyers being present, but others are not present. Witnesses are not present, because we have experience of taking evidence, particularly in arbitrations. We have practice of taking evidence over video conferencing, and one of the very first ones that I did in my career was over 20 years ago, and we were hearing evidence from witnesses in China, and the tribunal was sitting in London, and I was in London with my instructing solicitors. My clients were Chinese, and we were taking evidence by video conferencing. And we started at, I think, 9 o'clock in the morning, went on till 1, and then started again at 2 o'clock in the afternoon, went on until 5. It was quite late in China by the time we finished, but the line didn't break, and the video played very well, and we were able to get the evidence, the examination of the witnesses, the cross-examination, all done. And a lot of it was being done through interpreters, because a lot of the witnesses were not able to speak the language. So when we talk about advocacy, virtual advocacy, there are things that need to be done. You see, remote advocacy is an art, and this is something that we are not skilled to do at the moment. And I know that the Inns of Court College of Advocacy in England has issued some principles of remote advocacy. So to go on to advocacy, there are certain things that you must do. For instance, like to start off, as a matter of practice, what can be done is that if we were to liaise with all the parties and the judge's clerk in advance, and any documents that we want to present, if those were presented to the judge in advance and he were able to read it, then I think probably things would get much easier and it would be much better to handle. So we will have to think of new protocols for advocacy in virtual courts, in virtual hearings. The old protocols will go, because the time will, once a case is fixed and everyone is available. And I know that Justice Sarkar is one who is, I think, quite famous for this. So if he has fixed something, he would want the case to be heard, irrespective of difficulties that counsel have. Because in most cases that he hears, he has 2 or 3 counsel available in front of him. So on one side. So if one counsel, senior counsel, is not available, there's a junior counsel available, and he would be able to then carry on with the submissions. So that is something which is very useful. And whenever the case is fixed, I have found that the cases are heard. So this is something which is part of the new normal. And I think this will certainly be beneficial to the litigants, because one of the worries that that we all have is that justice delayed is justice denied, and we fear that the litigants are always concerned, oh, when is my case going to be finished? When is my case going to be finished? So that is a real problem that we have. So we need to liaise in advance, and we also need to understand the technology. So that is something which is necessary. The technology is to be used to our advantage, to the advantage of the hearings, and for the purpose of advancing the case of the litigant. So that is something which is important. We have seen in practice that on many occasions, everyone's speakers are kept on and background noises come in. There's echoing and things like that, which affects the sound quality. So those are things that need to be, obviously, we need to get used to. Obviously, when we are speaking in a physical court, we want to ensure that we are heard by the judge, and we are not speaking too softly or too loudly. So you have to have a balance. But here, because you can't see the reaction necessarily of the judge, you'll have to still be a bit careful. You'll have to understand to position yourself in such a way that you're facing the camera and not looking at the thumbnail at the bottom, where your face is. So you're speaking directly to the microphone so that you're audible. So all of these things that we need to know as far as the technology is concerned. So the essential part is that all parties must be able to hear you and see you. And that is the important thing, because in a virtual hearing, although we are in different places, nevertheless, the judge should be able to see everyone. And we should be able to see the others as well, because our colleagues who are appearing. So these are the sort of things that we need to understand, and that's going to be part of the new normal. I think I've spoken for quite a long time. You have not interrupted me or asked me a question, but if you have a question, I will answer it. But I think I should give way to His Lordship. He's been waiting for the two of us to speak before he goes. But obviously, I would want to give the floor to him to hear about his experiences.
Thank you so much, sir, for your wonderful thoughts you have shared about the virtual court system. Now we move on to Mr. Justice Muhammad Khurshid Alam, sir, with a question. Sir, from a litigant's perspective, are the litigants getting benefits from the virtual court practice from a judicial perspective? And if it is so, then how it's improving the judicial system countrywide?
For inviting me here. Actually, judges are not habituated to speak publicly. When I was in the bar, I was trained to speak before the judges, but in these 9 years, I have almost forgotten how to speak publicly. Nevertheless, I'm here to say something. The question that you have asked me, the answer from me is that, of course, the litigants are being benefited hugely. But the system was introduced suddenly, abruptly. That is why the new lawyers, the young lawyers, particularly the lawyers who are not trained in using this IT device, they were coming up with sort of objections and they were not happy with this system. And in order to resolve this issue, my suggestion is that there should be mixed, there should be hybrid system in place. If a judge is sitting in the room, that is sitting in the courtroom or in the khas kamra, his chamber, can connect those who wants to conduct the hearing virtually, and at the same time, if a judge can hear the matter actually, and with the passage of the time, I believe that the lawyers will be accustomed. So the benefit should go both to the lawyers and the litigants. Your question is only for the litigants, but I would say that the lawyers also should be benefited. Here only a section of lawyers are being benefited because they have all the facilities to be connected with the virtual court. But the lawyers who are not well off or who are not trained to do these cases virtually, because of their unhappiness, now we have again resumed the normal function. So this new normal, as uttered, as expressed by the both the panelists, is not any sort of complicated thing. So there is the responsibility from both the government, from the Bar Council, and from Bar Association. They should take up some programs to train them up, to encourage them to practice through virtual form. And the beginning should be by this way, that the courts which are now conducting their cases in actual form, that is physically, if these courts at the same time conduct their hearing also in virtually, then the lawyers who will be sitting in the courtroom will have the opportunity to observe, to watch the court's proceedings, and I believe that eventually they will be encouraged. Yes.
Thank you so much. To hear more from you, we would like to play a video clip that has been requested by Mr. Mr. Mustaq Ahmed Sadiq, sir, the former president of DBA. He has to say something about virtual courts and its aspects. So before we move further, we are going to have a look at his video clip.
এই প্যান্ডেমিক সিচুয়েশনের মধ্যে সরকার ভার্চুয়াল কোর্টের উদ্ভাবন করেছেন। পত্রপত্রিকা খুললেই দেখতে পাওয়া যায় বিচার প্রার্থীদের হাহাকার, কোর্টগুলোতে লক্ষ লক্ষ মামলা ঝুলে আছে বৎসরের পর বৎসর, এর কোনো সুরাহ হচ্ছে না। এর কোনো প্রতিকার, এর কোনো উপায় আছে কিনা আমার জানা নেই। আমি প্রতিকার করার চেষ্টা হচ্ছে, প্রত্যেক সময়ে সরকার বলতেছে এই কয়েকদিনের মধ্যে সমস্ত মামলার জট খুলতে হবে, মামলা শেষ করতে হবে। এখন ভার্চুয়াল কোর্টে কিছু কিছু মামলা হচ্ছে শুনতে পাচ্ছি। আবার যেসব মামলার আসামি জেলে আছে, মামলার আসামিদেরকে জেল থেকে এনে ভার্চুয়াল কোর্টে প্রোডাকশন করে বা সাক্ষী কিভাবে হচ্ছে তার কিন্তু সুনির্দিষ্ট কিছু এখন পর্যন্ত জনসাধারণ জানে না। তবে যেসব কেসগুলো অনেক দিন ধরে পেন্ডিং পড়ে আছে, যেগুলোর সাক্ষীর প্রয়োজন নাই, সেগুলো ভার্চুয়াল কোর্টে হতে পারে এবং ভালো হওয়া উচিত, এবং জনসাধারণের একটা সমস্ত এই ব্যাপারটা সবাইকে বুঝতে দেওয়া উচিত যে ভার্চুয়াল কোর্টটা কি। এবং এই কোর্টে ধরেন ইনকাম ট্যাক্স, ভ্যাট, কাস্টমস বা অন্যান্য কোম্পানি কেসগুলো ভার্চুয়াল কোর্টে হতে পারে, যার কোনো ইয়ে করতে হবে না, কারণ নথিপত্র দেখলে যেটা হবে যেটা ভার্চুয়াল কোর্টে হওয়া সম্ভব। কাজে আমি আশা করি যে এই ব্যাপারে একটা সাধারণ জনগণ যেন ভার্চুয়াল কোর্টটা কি সেটা বুঝতে পারে। তাতে একটা জিনিস হবে যে কিছু সাজেশন, হয়তো আরো ভালো সাজেশন আসতে পারে যে ভার্চুয়াল কোর্টে কিভাবে কাজ করতে হয়। এবং সবচেয়ে বড় যে জিনিসটা হচ্ছে সেটা হচ্ছে বহু কেস পেন্ডিং আছে, তার সুরা হওয়া দরকার।
Sir, now we would like to know from you যে উনি যে কথাটা বলেছেন ওনার ভিডিও ক্লিপের মাধ্যমে about the virtual court system and how the backlog of pending matters should be handled. Sir, এই বিষয়ে যদি আপনি একটু ডিটেইলসে বলতেন।
ওয়েল, এটা খুবই সম্ভব। প্রথমত ব্যাকলগ ইস্যুটা করতে হলে অনেকগুলি বিষয় আসে। তার মধ্যে ফার্স্ট ইস্যু হচ্ছে inadequate number of judges. আমাদের দেশে যত ডিসপিউট হয় সিভিল নেচারের অথবা যত ক্রিমিনাল অফেন্স হয় এবং যেগুলি আলটিমেটলি কোর্ট পর্যায়ে আসে, সবই যে কোর্ট পর্যায়ে আসে তা না। There are civil disputes which may be resolved through arbitration or which may be through other forum like FCIArb and other forums. এবং ক্রিমিনাল অফেন্স অনেক কিছুই হয়, সবই যে কোর্টে আসে তা না, অনেক, এটা সংখ্যা খুব কম যদিও। তো এই সিভিল এত ডিসপিউট, এত কেস, সে তুলনায় হাইকোর্টের সংখ্যা আদালত বসে থেকে 50টি, জাজ আছেন 90, 90 to 90, মাঝে মাঝে 100 থাকেন। আর 64টা ডিস্ট্রিক্টে যে পরিমাণ জাজ, যে কোর্ট আছে, সেগুলিরও নিয়োগ সবসময় দেওয়া সম্ভব হয়। এটি একটা ইস্যু। এখন আমার দেশে যা আছে সেগুলি থেকে যদি কমাতে হয়, তো সেখানে ফার্স্ট যে ইস্যুটি আছে সেগুলি হচ্ছে প্রসিডিউরাল ডিফেক্ট। সিভিল সিস্টেমে কোর্ট পরিচালনা করার জন্য, মামলা ডিল করার জন্য, রায় দেওয়ার জন্য আমাদের একটা আইন আছে, সিভিল প্রসিডিউর কোড। আর ক্রিমিনাল কে হ্যান্ডেল করার জন্য সাক্ষী নেওয়া থেকে শুরু করে স্টার্টিং ইনভেস্টিগেশন, প্রথম হয় তদন্ত শেষ হলে এর একটা পর্যায়ে শুরু হয় ট্রায়াল শুরু হয় চার্জ ফ্রেম দিয়ে, যে একজন অ্যাকিউজকে জিজ্ঞেস করা হয় তোমার বিরুদ্ধে তদন্তে এসেছে যে তুমি এই অপরাধে অপরাধী, তখন থেকে শুরু হয়। আমাদের দেশে যদিও মানুষজন ভাবে যেদিন থেকে ম্যাজিস্ট্রেট সাহেবের সামনে একজন অ্যাকিউজডকে নিয়ে যাওয়া হয় সেদিন থেকেই বোধহয় ট্রায়াল শুরু হয়, কিন্তু ট্রায়ালটা শুরু হয় অনেক পরে। যেমন অনেক আলোচিত কেস রুনি সাগর মামলা, এখনো তার বিচারই শুরু হয়নি। মানুষ মনে করে যে এখানে বোধহয় জুডিশিয়াল বিভাগের একটা বড় ধরনের গাফলাতি আছে, কিন্তু এখানে এখন পর্যন্ত ট্রায়ালই শুরু হয়নি, কারণ ওটার কোনো ইনভেস্টিগেশনই হয়নি। ইনভেস্টিগেশন হবে, একটা রিপোর্ট আসবে কোর্টের সামনে, কোর্ট যদি তখন থেকে বলে যে আমি চার্জ ফ্রেম করতে গেলাম, তখন থেকে বিচার শুরু হয়। তো এই ক্রিমিনাল সিস্টেমে ইনভেস্টিগেশন একটা ইম্পর্টেন্ট পার্ট, একটা ফেজ, তারপরে ট্রায়াল শুরু হয়। তো ট্রায়ালে আমার মনে হয় না যে খুব বেশি সময় লাগে, যদি না প্রসিকিউশন অর্থাৎ পুলিশ এবং সরকারের কিছু এখানে ভূমিকা আছে, তারা যদি আন্তরিকভাবে দায়িত্ব পালন করে, যেটি এই ফর্মার প্রেসিডেন্ট অফ এই অ্যাসোসিয়েশনের উনি যে বললেন যে জেলখানা থেকেও সাক্ষী নেওয়া সম্ভব। যেভাবে আমরা লয়ারদের কানেক্ট করতেছি সেভাবে জেলখানায় জাস্ট আমাদের এভিডেন্স অ্যাক্টে এভিডেন্স নেওয়া সংক্রান্ত যে বিধানটা আছে, দুটো লাইন ওখানে যোগ করে দিলেই এই অবস্ট্যাকল, এই ব্যারিয়ার, এটাও আমরা ওভারকাম করতে পারি। তো এই যে আমাদের প্রসিডিউরাল যে বিষয়গুলি আছে, সেই প্রসিডিউরাল বিষয়গুলি নিয়ে এটাকে সরকারকে ভাবতে হবে। খুব দুঃখের বিষয় হচ্ছে যে সেই প্রসিডিউরাল আইনগুলি এখনো ইংরেজিতেই আছে। আমরা যদিও 50 বছর এই স্বাধীনতার কয়েকদিন পরে আমরা পালন করব, তো এখন পর্যন্ত যেগুলি এই ধরনের আইন, এই আজকে ব্রিটিশ দিয়ে গিয়েছে সিপিসি সিভিল প্রসিডিউর কোড অথবা সিআরপিসি ক্রিমিনাল প্রসিডিউর কোড, এইটা এখনো বাংলায় অনুবাদ করার মতো সময় আমাদের হয়নি। কারণ এইগুলি প্রথম ব্যবহার হয় 64টা ডিস্ট্রিক্টে, সাধারণ মানুষ এটা ব্যবহার করে। বাংলায় এখন পর্যন্ত আমার রাষ্ট্র এটাকে বাংলাই করতে পারে নাই, অথচ ওখানে যে লয়াররা ওখানে প্র্যাকটিস করতেছেন, সেই লয়াররা তাদের লেখাপড়াটা ইংলিশে হয়নি। হয়তো আই ওয়াজ ফরচুনেট যে আমি ঢাকা কলেজ, ঢাকা ইউনিভার্সিটি ব্যারিস্টারি পড়েছি, আমি এত মোটামুটি ইংলিশ পারি, কিন্তু ও তো পারে না। ও যে 64টা ডিস্ট্রিক্টে যে প্র্যাকটিস করতেছে 90% লয়ার, তার সামনে যে এই দেশের যে এলিমেন্টারি ল স্ট্যাটিউট যেগুলি, ল বুক যেগুলি, সিপিসি সিভিল প্রসিডিউর কোড, ক্রিমিনাল প্রসিডিউর কোড, যদি ক্রিমিনাল মামলা হয় তাহলে পেনাল কোড আসে এবং এভিডেন্স অ্যাক্ট আসে। আমি যে কয়েকটা স্ট্যাটিউটের কথা উচ্চারণ করলাম, একটিও বাংলায় হয়নি এখন পর্যন্ত। 50 বছরে আমার রাষ্ট্র, আমার সংসদ এখন পর্যন্ত এটাকে বাংলায় করেনি। ঠিক সিভিল প্রসিডিউর কোড, সেটাও বাংলায় হয়নি। আর সিভিল নেচারের যে সমস্ত আইন আছে, এখানে আলোচনা হলো কর্পোরেট ল নিয়ে, সেই নেগোশিয়েবল ইনস্ট্রুমেন্ট অ্যাক্ট, সেইটা এখনো ইংলিশে আছে। এবং অন্য যত ধরনের আইন আছে, এই বাংলাদেশ স্বাধীন হওয়ার পরে যে আইনগুলি হয়েছে সেগুলি বাংলায় করা হচ্ছে। তো এই অনেকগুলি কারণের মধ্যে এগুলি একটি। এখানে লিগ্যাল এডুকেশন চলে আসে, যখন তাদেরকে লয়ার হিসেবে ট্রেন আপ করা হবে। এই এলএলবি যাদেরকে পড়ানো হচ্ছে, তারা ইভেন্চুয়ালি আইদার দে উইল বি আ লয়ার অর দে উইল বি আ জাজ। সুতরাং এখানে একটা গুরুত্বপূর্ণ বিষয় আছে যে মামলা যে ব্যাকলগ আছে সেটা কমানোর জন্য ওই জায়গায় কিভাবে ট্রেন আপ করবে, ওখানে থেকে যেভাবে ট্রেন আপ হয়ে আসবে, তারপরে স্টেজটা হচ্ছে সে যখন প্র্যাকটিস করবে, সেই যে চেম্বারে কাজ করবে, তার হাতে কলমে কাজ শেখানোর পাশাপাশি মানসিকভাবে তাকে যে ট্রেন আপ করা হবে, সেটাও একটা গুরুত্বপূর্ণ বিষয়। যে সে কি শুধু মামলা ডিলে করলে তারিক আফজাল সাহেবের কাছ থেকে ব্যাংকের লয়ার হিসেবে বেশি বেশি ফিস পাবে, নাকি এটা তাড়াতাড়ি করলে এটা দেশের জন্য ভালো, তার জন্য ভালো, ব্যাংকের জন্য ভালো। তো এখানে এই ব্যাংক এবং অন্যান্য যারা প্রতিষ্ঠান আছে তাদেরকে চিন্তা করতে হবে যে কি করে মামলা তাড়াতাড়ি শেষ করবে তার লয়ার, এবং তার মধ্যে এই বিষয়টা কাজ করবে না যে না তাড়াতাড়ি শেষ করলে সে তো ফাইন্যান্সিয়ালি বেনিফিটেড হবে না। সর্বশেষ কোর্টে এসে যে কাজগুলি হয়, যেখানে যখনই লয়াররা কোনো অ্যাডজর্নমেন্ট সিক করে, কোর্ট সেখানে একবার দুবার দেয়, যদিও কিছু আইনে, যেমন অর্থ ঋণ আদালত আইনে এখানে বলে দেওয়া আছে যে এরপরে যদি সে টাইম আবার সময় চায় সেক্ষেত্রে ফাইন করতে পারবে, তারপর এক্সপার্টির জন্য যেতে পারবে। তো এগুলি অন্যান্য আইনে ওইভাবে যদি নিয়ে আসে তাহলে মামলা তাড়াতাড়ি করা সম্ভব হবে। তো এই সিস্টেম যেটা চালু হয়েছে সেই সিস্টেমের মধ্যে ওই অ্যাকচুয়াল কোর্টে যেগুলি আছে এগুলি সবই সম্ভব। আমি যে বিষয়গুলি বললাম, if all the issues are addressed and dealt with properly, I think the country, the litigants, the lawyers, the judiciary as a whole will be benefited.
Thank you so much, sir. Now we are going to move on to Mr. Tarique Afzal, sir, with a question. Sir, does bank as a litigant prefers open courts over virtual courts? Just kindly state your notion. That's what we want to know.
Thank you so much. It was a delight to hear the Honorable Mr. Justice Sarkar, His Lordship, and the learned Barrister Ajmalul in Queen's Counsel. It is a very eye-opener for us who are not used to the automation processes in the judiciary at large, because it has been an old school for me personally, for multiple reasons, and for the honorable judges and the lawyers practicing in the country itself. Now, traditionally, you're right, traditionally the entire industry and the entire country is used to, in a course of a physical presence in a court, hearing, arbitration, seeing the proceedings, and at the end getting a verdict from the honorable judges. But as the learned Queen's Counsel had stated that it is so very becoming efficient in the international world as a global practice that it has gained time and cost efficiency. Because in multiple cases, as you rightly say, time is of the essence for the either aggrieved or the beneficiary parties. So if there is a process that can be established in future, could be parallel, could be a physical court and a virtual court as well in bifurcation, that could definitely benefit and expedite the process of pending cases, as His Lordship has kindly stated, that if we can gain human efficiency in different levels, and if the language and in the CPC codes can be converted to a language that is more friendly to the local lawyers, that can benefit the lower courts and the higher courts especially to resolve and dispose of cases. So that will benefit the industry of banking, and I'm sure clients and us at large. And that would perhaps be an ideal scenario in the near future as new normal, that we are that perhaps this pandemic has worked in both ways. It's a two-edged sword that that can be beneficial for future, that we've been waiting for digitalization, and that has suddenly expedited the process to reach there. As you know, the Honorable Prime Minister of Bangladesh has a vision, which it was a vision of 2020 and plus for digitizing the every scenarios of system of the government of Bangladesh. So I think we are one step forward, and I'm sure this will benefit this new normal scenario, and the virtual scenario can benefit the backlog process in disposing of cases. Thank you.
Thank you so much, sir. Your notion means a lot for us. Now we move on to Mr. Ajmalul Hossain QC, sir. Sir, as you already well known for your experiences practice in international jurisdictions, in that aspect, would like to point that a recent article published in India actually criticized the concept of virtual court system. This criticism was uttered by an advocate of Supreme Court of India. He said in his statements that virtual hearings are far from satisfactory and are deeply disappointing as he gets to hear lots of complaints of lawyers, stating some missing out on hearings, being disconnected halfway, or limited resources and lack of digital infrastructure. He himself, being a member of the Supreme Court Bar of India, he was immensely concerned about how to help litigants because he thinks that the justice system of India failing to be more accessible for litigants. Do you think similarly Bangladesh might face the same scenario? If so, what can be done to resolve it?
Forgive me, I wasn't following the rules. I was muted. It's a very burning topic, obviously, hearing in virtual courts. And I can understand the criticism that is being brought by the lawyer in India, our colleague in India. He obviously is taking a traditional view, and the traditional view being everyone must have his day in court. So when you talk about a day in court, you want to go into a physical court building, you want to go into actual court room, and you want to see your actual judge, you want to see your lawyer, you want to see the witnesses, you want to see everyone present there. So that is the old normal. That was the position before. But certainly arbitrations, I have seen, as I said, 20 years ago, arbitration we were doing we were doing virtual hearings. We were taking evidence over video conference lines. So, and even there were times when I was making submissions over the telephone. I was doing an arbitration. One of the arbitrators was in Australia. One was in England, and the other one was, I think, in Singapore. And I was in Dhaka, and I was making submissions over the phone. And my colleague on the other side, he was actually making, he was actually phoning from the air. He was on a plane traveling between London and New York, and he was making submissions from the plane. So you can see the advantages of having virtual hearings. That you can be anywhere, and obviously confidentiality is a big issue. And one of the things that we need to do is to ensure that whenever we're doing cases over the telephone or videos, that we are in a private area and other people do not have access to the information that is being spoken, or the information that is becoming available and can be heard by other people. So we want to avoid that. But nevertheless, I can understand the criticism. But nevertheless, I think he will eventually change his ways when he gets used to the new normal. I'm sure our colleagues who are opposed to this system will get used to it, and we'll see the benefits of it, because there are advantages. We don't necessarily have to go into court to make submissions. If we can make the submissions from our home, it's going to be useful for us because we are saving time. And also, what is going to happen is, as I've seen, arguing cases before Justice Sarkar, and others who have been hearing cases virtually, that you learn to become precise and you make your submissions in a concise way. So you don't have the liberty of just reading pages and pages and pages and pages of documents. You just go straight to the heart of the matter. You don't overspeak. You go to the precise point that needs to be addressed, and you do your advocacy in that way. And also what you do is you make written documents. You prepare what we call a chronology of events. Some people call it a date chart, so put everything in a date order and send it to the judge in advance. And if you can present something like that to a judge, all the facts and the dates that need to be looked at can be looked at very briefly and very quickly. And you can make very precise submissions. So those are the advantages. Obviously, those people who are not used to this, they will have to learn to become precise, and they will have to prepare their case properly so that they will be able to argue it. And there's no point in wasting the court's time. Obviously, the court's time is valuable, the judge's time is valuable, and the more time you waste, you're actually holding back the next litigant. That is the thing that we have to be aware of. That if we take too much time, then we will be avoiding, we will be sort of putting the next litigant at risk because his case will not be reached that day. Maybe he has something very urgent which needs to be placed before the court. So that is something that we need to be very conscious of. So we are not only thinking about our own client, but we're thinking about the litigants in general. And I think at the present moment, having seen virtual courts in practice in Bangladesh, having seen virtual courts in practice in England, having seen virtual tribunals taking evidence and so on for many, many years, and hearing submissions for many, many years, I think this is going to take off, and it is going to be beneficial to the litigants and to the lawyers who represent the litigants. Because at the end of the day, we are providing, the justice delivery system is providing a service to litigants. So we have to keep the litigants in focus. And as Tarique Afzal has said, that he's concerned about the number of things, delay, cost, and so on. So these are the things that I think can be addressed by actually using virtual courts and virtual hearings.
Thank you so much, sir, for your commendable views. So now the question I would like to ask to Mr. Justice Muhammad Khurshid Alam Sarkar, sir. Sir, how E-Judiciary is transforming the justice system, enhancing transparency and effectiveness to it?
When it will come into force, will be benefited for the country. Now, I would say that in our country, the benefit of E-Judiciary has started longing, in the sense that all our judgments, all our orders are being stored in our computers and IT device. So just before a few years, this system was not in place. We used to deliver judgments in papers, and all the judgments were stored in our storeroom. Nowadays, most of the judgments are being stored both in storerooms as well as in computers. The rest of the systems, the rest of the procedures for dealing with cases and that is hearing of a case, starting from filing of a case, then hearing of a case, then delivery of a judgment. If it is started slowly, then of course I would say that the litigants, the lawyers, the judges, and the country as a whole will be benefited. Thank you.
Thank you so much, sir, for your wonderful comments. Sir, now I would like to know one thing, that based on Tarique sir's views as well as on QC sir's views, how you could say that virtual courts, can they replace open court hearings?
Well, they can, if the lawyers are trained, if the judges are trained, and also the litigants who want to see his or her case is being conducted properly, then it may take place. It may take the place of actual hearing. So the passage of time, I think it is possible. For this, the government should take initiative. Both the Ministry of Law and the Office of the Chief Justice, as well as the lawyers community, that is the Bar Council, they should also come forward to introduce this system. Yes,
thank you. Thank you so much, sir. Thanks to all the esteemed panelists for being with us in this legal webinar. Your presence have enlightened the program, and thanks to all viewers for participating in our program. Your participation means a lot as an appreciation. Till then, take care, stay safe, and keep an eye for our upcoming segment to be held on upcoming Friday. Thank you so much. Thank you, all the panelists, respected panelists. Thank you so much.
Thank you very much.
Thank you.